Thank you so much, Kelly. Welcome everybody to this important session on a topic that is, of course, very timely and that touches on so many different areas of law. My name is Omid Feruzi. I'm a staff attorney at Philadelphia Legal Assistance in our low-income taxpayer clinic. And for the better part of the last 2 years, I've been focused on this issue of worker misclassification and helping people challenge their misclassification for federal tax purposes. And so that's what I'm going to be talking about today. And I'm joined here by my colleagues, Nadia and Julia. Nadia, if you want to discuss what you'll be talking about today.
Hello, everyone. Nice to see some friends on here. So hopefully I don't embarrass myself in front of you. This is Nadia Hefka. I'm an attorney at Community Legal Services of Philadelphia, and I'm going to be talking about misclassification in the wage and hour context. Julia?
Hi, everyone. For those who don't know me, I'm Julia Simon Michelle. I'm the supervising attorney of the Unemployment Compensation Unit at Philadelphia Legal Assistance, and I'll be focusing on the effects of misclassification in unemployment.
So one thing I want to mention is that we will be taking questions at the end. So please put your questions in the chat and we'll be monitoring them. And then once we're all done, we'll take everyone's questions after we've all presented. But first today, I'm going to hand it off to Nadia, who will be sharing her screen and kicking off this presentation.
Great. So again, I guess before I get started with the presentation, I was wondering how many folks in our Zoom room do wage and hour, any wage theft or wage and hour work at all? You can put your thumbs up or clap in your reaction section. I think a lot of folks do unemployment maybe, and maybe not as many do wage and hour. All right, I see a few thumbs up on both of our pages. So that's something that's good to know. It will not change my presentation one iota. I'm going to talk a little bit about overall view of misclassification. Misclassification affects workers in a lot of different ways. So we're just focusing on the three areas that we mentioned, which is wages, unemployment, and taxes. So I want to start with wages, and but also tell you that it goes beyond wages, obviously. Okay, so let's talk a little bit about misclassification and what it is overall. Misclassification is hard to say exactly for those who've tried to quantify it, but it's estimated 1 in 10 workers and is greater and lesser in certain industries. There's a study that found that 1/3 of construction workers in the South were misclassified. So we do see a lot of misclassification coming up in the residential construction and other kind of construction. It is part of the trend towards a fissured workplace in terms of subcontracting, temporary staffing, outsourcing, etc. The way a janitor at a office used to be employed by the business and is now employed by a different company. These are all part of a trend. But overall, the practice of misclassifying workers undermines workers' rights, depresses wages, and disarms collective action, because if you're not seen as an employee, then you lose out on many different workplace protections. Also has a huge impact on local, state, and federal tax collection, and therefore public goods that we all depend on. And it creates a problem within industries where certain employers are undercutting others. If you want to read more about the trends, there's a David Weil, who used to run the wage and hour division of the U.S. Department of Labor under Obama, wrote a lot about this and focused on this a lot while he was in the DOL. So, who is an employee and who is an independent contractor? It's not always misclassification, so let's get that clear. If you are an employee, then, I'm sorry, let me close this out. It's generally determined by common law, sometimes by statute. If you're an employee, you have a boss, someone else sets your wages and working conditions, and you are helping to build someone else's business and not your own. Also, if you're an employee, you can be fired, right? And that's a key part of that. Who is an independent contractor? Someone who's in business for themselves, someone who makes investments in order to sustain and grow a business, and someone who negotiates and sets their own prices with clients. You're not being told, what the price is by somebody else. That would be a very boss-like thing to do. So the impacts of calling workers independent contractors are, the following under the employment laws. As an independent contractor, you get no right to minimum wage, no right to overtime. Employees get workers' compensation, and independent contractors don't. Employees get an unemployment, and independent contractors don't. All of the discrimination laws, including harassment laws, apply to employees and not independent contractors. There's a small trend to remedy that right now. The right to form a union and collectively bargain is also a right reserved to workers or employees and not independent contractors. And employer-provided retirement benefits are usually not provided to independent contractors. So that's a sampling of the different employment impacts. Then the cost to the worker is something Omida is going to talk more about, but the huge cost to independent contractors is that they have to pay their entire self-employment rate at 15.3, whereas employees split FICA and FUTA 7.65 each. So as well, under independent contractors have to provide their own insurance and cover injuries on their own, whereas employers pay for workers' comp. Employers usually can't deduct other like employee expenses like uniforms, etc., whereas independent contractors are responsible for bringing anything they need to the job on their own. Just a quick overview. We're not going to talk too much about how to fix this big problem broadly, but there are efforts afoot by forces on the right. By forces on the right to carve out certain transportation jobs for to make sure that those workers are not classified as employees and can be classified as independent contractors. So there's a lot of back and forth and fighting over this issue because the cost, the bottom line to the businesses are huge. If they can get away with calling someone an independent contractor as opposed to an employee, they save a lot and shift those costs on the workers, right? So this is where certain kinds of legislation have been passed or are working on being passed, and luckily Pennsylvania is not one of them yet, but we can expect that may be happening soon. This is an organized effort. There's another type of bills that want to exempt certain kinds of like platform employers from misclassification, efforts to fight misclassification. Who is getting misclassified? Power really about who gets to set the terms of a job. The lack of enforcement is another whole topic that we can get into, and we can talk about who is up for this fight in Pennsylvania, because people are getting misclassified every day, and if you raise it in one forum, it doesn't necessarily get fixed in other forums. But like I said, in construction, there's a lot of misclassification. So painters or drywallers really should only be independent contractors if they are the ones setting the terms of their pay and are and the way they perform their work, whereas a lot of times they're not. A lot of times they're just being misclassified. They are someone else's employee. In the construction area, this is the one area where we do have a law in Pennsylvania where there is actually some protection for construction workers, where there is a presumption that you're an employee and not an independent contractor. And so I would recommend that if you have a lot of construction worker clients to take a look at the Construction Misclassification Act. So that is one area. And why is that there? It's because there's some power in some of the unions that represent workers in those industries that pushed for this. We should look at getting something broader than that to apply to all workers, from my opinion. Where we also see it, we see it in home health, we see it with nannies. I see it a lot in therapists, like providing mental health services, for instance, for different mental health, for different health practices. We see it a lot in nail salons. We see it a lot in a variety of different, industries, and in temp work, we see it. A lot of the misclassification also serves a purpose for employers who are trying to avoid doing I-9 checks in terms of whether someone is legally authorized to work. So this is another driver of misclassification. And sometimes you'll find that workers are willing participants in that if it's their only way to work, but there are costs to that as well. There are many other areas where we see this, but that's just a smattering of the kinds of cases. You can see it you see it in pizza places, frankly. You can see it anywhere, but those are some of the big ticket areas where we see misclassification. So let's get to the labor laws. I'm gonna try to be mindful of my time and not get too deep into any of this, but I would encourage you that if you come across any wage and hour issues and there's a misclassification issue, contact us at CLS and we'd be glad to try to talk it through with you. So for the Fair Labor Standards Act, which is the federal law on minimum wage and overtime, be aware that there's new regs that are currently pending. And if you care about this issue, you might want to check out the sample comments that the National Employment Law Project has put out. They are due next week. So if your organization is able to sign on, surprise, surprise, the new regs would loosen the test and make it easier for businesses to classify workers as independent contractors. The current test is the economic realities test under the Fair Labor Standards Act. And so really what you look at is not what the employer calls someone, whether they're given a 1099, et cetera, but it really is looking at what is going on in this employment relationship. To what extent are the services this worker is providing to the business, to what extent is that an integral part of the employer's business? Is the relationship between them permanent, or is this just like a little gig for a couple of weeks? Is this is the alleged contractor investing in facilities and equipment and basically in their own business, or is everything provided by the employer, by the alleged employer? How much control does the employer have over the way that you do your work? Is it up to you to set your hours and what order you're going to do your work in and how much you get done in a day, or are you being supervised and monitored all the time? What is the alleged contractor's opportunity for profit and loss? So again, if you finish the job quickly, and you get paid the same amount, that means you've profited because you can move on to the next job. But if you're paid by the hour, then you don't really have an opportunity for profit and loss if you finish quickly. In fact, that's kind of a loss, right? So the more the contractor is able to benefit from doing a job quickly and efficiently versus in some other way, then that person would be an independent contractor. The amount of initiative, judgment, or foresight in a competition with others, I don't think this is one of the main factors. And the degree of independent business organization and operation. Again, does the alleged independent contractor have a business card, advertise, have a bunch of clients that they work for? All of these are things that the Fair Labor Standards Act takes into account. But that could change if the new regs come into effect. Okay, the Pennsylvania Wage Payment and Collection Law. Those of you who do wage law in Pennsylvania know that we have the Pennsylvania Minimum Wage Law, which covers minimum wage and overtime, but non-payment of wages is usually something that you bring a claim under the Pennsylvania Wage Payment and Collection Law. The benefit of doing that also is that under the Wage Payment and Collection Law, you get promised wages, not just the minimum wage. So if you are promised $12 an hour, then you can get the full 12 and not just the minimum wage of $7.25 an hour. You can also bring claims for other benefits. So if you're misclassified and therefore not getting health care, then you can, or retirement benefits, then you might be able to bring that under a WPCL claim. So we bring claims together with the FLSA where there is overtime and other things. Under Pennsylvania law, control is the key factor of the list of factors I listed earlier for the FLSA. Control is the key, and that is the person subject to the alleged employer's control or right to control with respect to his physical conduct in the performance of the services for which he was engaged. So an employer not only controls the results of the work, but also has the right to direct the manner in which the work is accomplished. Whereas for an independent contractor, the person engaged in the work has the exclusive control of the manner of performing it. So think again back to the drywall example. And if you, as the drywaller, negotiated how much you get paid by the job, and not by the day or by the hour. If you were responsible for getting all the supplies together, figuring out what order you're going to do the drywalling in the house, how many people you're going to hire under you, then you're probably an independent contractor. However, if you are being paid by the hour or the day, and you are given supplies and told when to show up, told how to do the job, where to do the job, someone is supervising your work, telling you you're doing this right, you're doing that wrong, then you're probably not an independent contractor, and you're probably a employee. So one of the big cases in Pennsylvania is Vallis versus Albert Einstein, and the slides are all available through Plan if you want to take a look at any of the things that we're referring to today. Okay. I think I only have a few minutes left because we want to save time at the end. So again, this is a very cursory overview of wage and hour implications, but contact us if you want more assistance. You may have heard about something major going on in California. There was a big case called Dynamex. So if you're interested in this issue, take a look at the Dynamex case. Basically the California Superior Court made some sweeping findings there after years of litigation, is my understanding, that they identified all the harms that are caused by misclassification of workers, looking not just at the workers, but also harms to law-abiding businesses that are not misclassifying, and to the state in terms of revenue, as we discussed. And because all of those multi-factor tests that we discussed control, who has control, it gives employers wiggle room, especially if they say, oh, my accountant said I could do this, right? It gives them some wiggle room under the law if they're relying on, the opinion of a professional, for instance. Under the FLSA, there is case law about that. So because all these tests give employers cover, and it makes it a little more difficult to say if someone's misclassified or not, California decided to create a presumption of employment, and that employer has to prove that this person is truly an independent contractor. And so, again, that is the way things are headed in a lot of different states because of the fact that misclassification is hard to find. Employees or alleged employees have to be brave enough to come forward and risk that they're going to get terminated and not have unemployment comp, for instance, if they are terminated after complaining or filing some sort of a complaint with a governmental authority. So creating a more bright line test is more protective of workers, and that's something that, or at least a presumption, is something that is a little bit more manageable for all parties, rather than having to fight employers every step of the way if they're to see whether they are misclassifying or not. So that's a big effort that Uber and Lyft are fighting hard right now in California through a statewide referendum. And I believe that's just about it. A few other suggestions people have are creating wage boards for collective bargaining. That's something that's happening in a variety of ways. I'm not super familiar with that, but that's something that we're exploring in Philadelphia as a way to get around some of these collective bargaining problems that independent contractors have. Statutory employment up right above it is what I just mentioned, is that where you make it clear by statute that that certain workers are employees. And also states have a lot of power in procurement to only give contracts to employers that are not misclassifying or are treating workers well. You could do, you know, Philadelphia has that for wages, but you could do that for misclassification. You could do that for recognition of labor rights as well. And then making misclassification a violation so that there are extra penalties on employers that are misclassifying. I believe that's it for me. Oh, look at that. There we go. I'm going to turn it over to my co-presenters. I believe Julie is next.
If I could just interrupt, this is Kelly. I need to launch the first of the CLE poll boxes. You'll have a minute and a half to respond. And Omid or Julia, please continue. Feel free.
I can go ahead and go next. Give me a second while people are doing this to share my screen as well. Okay, so we're going to quickly go through the impact of misclassification on unemployment benefits in this part of the session, and there's a lot of overlap with what Nadia has already talked about in terms of the tests and various approaches that are used. So I think, as many people are now more familiar with during the pandemic, the first step of qualifying for unemployment compensation at the state level is that a worker must be found financially eligible for benefits, which is based on a look-back period of that worker's wages to get an idea of how much they earned and when they earned. Now, where misclassification clearly comes in is that the financial determination only includes W-2 wages as they are reported by employers. So employers have the responsibility of filing quarterly reports of wages for their workers, and that is where the information is pulled. And so for those of you working on unemployment issues during the pandemic, you've noticed that there are many times that those wages are incorrect, or there's wages that are missing. And one of the main reasons they're often missing is that an employer has classified internally that worker as an independent contractor and not as a W-2 worker, and is therefore not paying taxes on their wages and not reporting them to unemployment. So when somebody's wages are missing and they believe that they were misclassified, the only way to get those wages included in the notice of financial determination is to appeal and go to an unemployment compensation referee hearing. Now, there's a step before that where a wage investigation can be done, and I think like once in a blue moon, the department on its own may find that the wages should have been included, but more often than not, it'll go to an unemployment compensation referee, and the referee is asking really one question, which is whether the work was done in employment under the unemployment compensation law. So the unemployment compensation law defines employment, and under the law, which is remedial in nature, there is a presumption that that work done for wages is employment, unless the employer can prove, or the department can prove, depending on the posture, that worker is free from control and direction, and that they are customarily engaged in independent business, right? So they have to prove both prongs before it takes someone out of the presumption that they are working in employment. So it's a little odd in that initially the wages are not included because the presumption is that whatever the employer reports is correct. But once you raise it to the level of an appeal, again, the presumption is actually on the side of the worker. So when a worker is contesting that their wages were not included in the financial notice of determination, it is actually the employer's burden at, or as they'll often refer to it, the putative employer's burden at that hearing to prove they were not employed, right? To prove those two prongs, that burden's on the employer. Now, in practice, if especially if an employer is not present at the hearing, referees will often engage the claimant, the worker, in a series of questions, pretty much kind of going through the different factors included in each issue, free from control and direction, independently engaged in a business, to try to develop the record in order to make a ruling on whether or not that person's wages can be considered earned in employment and therefore count towards their unemployment benefit rate. So the first prong, free from control and direction, it considers the totality of the circumstances. It's pretty similar to a lot of the other control tests that are out there, like the wage and hour test that Nadia mentioned, and same with the FLISA test, but each control test kind of has its own factors that are identified usually through precedent. And so there's a series of different precedents in Pennsylvania that enumerate the different factors that can be considered, but ultimately it's a totality of the circumstances analysis. The key here, and again, this is similar to what you heard before, is that it's not actually about whether the employer did exercise control, but also whether they had the right or authority to exercise control. So even if they choose not to use it, that doesn't mean that that automatically places someone in the role of an independent contractor as opposed to an employee. It's the same test in unemployment across the board, does not depend on industry. One thing to note is that if you are dealing with someone in multiple different areas, you have a client who is misclassified and you're dealing with in the wage and hour context, you're dealing with it in the unemployment context, maybe you're also filing a tax case, as Omid will talk about. Unemployment decisions on issues, on this issue are not controlling, and that they can't be used for collateral estoppel purposes. That has been held by the Pennsylvania Supreme Court under the idea that an employer may not fully contest this to the same extent they would if it was in the wage and hour context and there was kind of money on the line for an employer in a different way. And so while these can be super helpful, they are not controlling in other contexts, although that doesn't mean that they are not admissible and could not be helpful in some ways, but it doesn't mean that it is a settled issue outside of the unemployment context. For customarily engaged and independently established business, and let me just point out, Nadia mentioned the ABC test briefly. In essence, the test for unemployment compensation in Pennsylvania is the AC test. We just don't have the B prong. We actually had the B prong, but it was taken out in the late 1940s. Still unclear why, but it is now the AC test in essence. Under the C prong, there are really two analyses. One, the focus is on whether the business or occupation was independently established. This is really the idea of, can they operate on their own, or are they really reliant on an entity like an employer? And second, is the claimant customarily engaged in the work? And actually recently, the question of what it means to be customarily engaged in the work came before the Pennsylvania Supreme Court, because there had been this developing idea at the Commonwealth Court level that somebody could be customarily engaged as long as they could expand their work, or they could work more consistently, or they could have worked for other entities, right? This idea that they have kind of sole control over their work, and if they're choosing not to work more, then that doesn't necessarily mean that they're an employee. And the court really pushed back hard on that, and really said that it's not a hypothetical. It's not about what they could do. It really is only about the work they actually did. So if somebody was and it's one of the claimants in that case, which was a case assessing taxes, cleaned the floors at the nail studio, at the nail salon, just because they could have cleaned floors at other nail salons doesn't mean they were customarily engaged. They weren't actually doing that. That was the only place they were performing those activities for. And so I think that's a really important narrowing of that test for workers, and actually lines up with how customarily engaged has been interpreted in many of the other states that share this language, both in the wage and hour context and in the unemployment insurance context. So the second place where we see issues of misclassification come up are when people have already qualified for unemployment and then begin picking up other types of work and reporting that income while they are on unemployment. If some sort of income is reported that makes the unemployment authority think that somebody is engaged in self-employment, which is a term of art in the law, then they will often disqualify them from any benefits under this idea that once they've engaged in self-employment, they're not truly unemployed. They are in control of their level of employment. And so, again, this usually happens when somebody reports earnings. It's Section 402H of the law. And we see this happen all the time. We are constantly appealing and trying to contest those classifications. I have seen people investigated for things as crazy as somebody, as a client who was a cancer survivor, and as part of her rehabilitation and her medical support, was asked to fill out a survey and got paid $20 to fill out the survey and reported it to unemployment, and then they investigated her for self-employment. So their bar is really low, but I believe this is changing. We'll talk in one moment about a case that shows that, but there, I think, has also been some interest from leadership at the department to kind of reevaluate how they look at these cases at the ground level. So the big case that just came out was our case Lohman versus Unemployment Compensation Board of Review. It came out the end of July. It's a long-running case that started back in 2015 about whether or not an UberX driver could be disqualified from unemployment benefits under that section, under the self-employment section, 402H. And first and foremost, what the court held in that case was that when you're evaluating the relationship of a worker and an employer under the self-employment prong, you use the same exact test as you use in the initial qualification. So saying that two-prong test, that AC test, is the test that you use in the self-employment context. So in essence, finding that it's exactly the same, although one is called self-employment and one is called employment. And so what they found in Lohman was that looking at this UberX driver, they concentrated primarily on the role of Uber as the putative employer and Uber's conduct, and found that Uber controlled and directed the performance of the driver services as a driver for hire. And importantly, for people who are contesting the employment status of gig workers in both the unemployment context and other contexts, they really focused on that there was an application process, that they couldn't substitute to provide services, and that really there was this whole idea of like virtual monitoring, review, and supervision of his performance, right? A lot of times gig companies talk about how, oh, we don't actually supervise, or train, we provide guidance. And the court really shoved that to the side and rejected that and said, really what is happening here is review and supervision. And that's especially the case because they're all tracked by GPS. They looked at the pay structure, and interestingly enough, they also focused on the tools and equipment. So usually tools and equipment go against workers in the gig context when we're talking about misclassification. But finally, we got the court to recognize that actually the most important tool for all of these workers is the app that they cannot perform these jobs. They cannot perform this work without the app. And this, I believe, is the first case that really holds that anywhere in the country and focuses on the fact that the app is really the be-all, end-all of this work. And then importantly, the court went a step further. As lawyers, you know that courts don't often rule on things they don't have to. So they could have just ruled on one of these prongs and stopped there, but they chose to rule on both. And in the second prong found that the UberX driver was also not engaged in an independently established business and really focused on the fact that under Pennsylvania law, they cannot legally provide driving services on their own. And that importantly, they can't create a customer base. They can't contact customers outside of Uber. They cannot set their own rates, which really differentiated this case from a previous case involving limousine drivers, where they found that those drivers were customarily engaged in independent businesses. So just a few more important takeaways that I think impact contesting misclassification of gig workers in general, because I think this case is widely applicable. Again, it used the AC test, very clearly the same test used for qualifying for benefits and in other areas of misclassification. There was a very heavy focus on the written agreement with drivers. And just to note, the written agreement is pretty consistent over the years and across states. They change it here and there, but the things that we're focused on in this case are the core values of their business and their product. So that has not changed. And a lot of the facts similarly exist with other platform businesses and companies. Again, I mentioned earlier the fundamental tool being the app, and that recognizing that the virtual world in which Uber operates, control looks different. I had mentioned during the oral argument we had in our briefs, it's different than someone in middle management looking over your shoulder in the office. But in reality, the effect is the same in terms of the control. And they also came back to this argument that Uber makes consistently, which is that, well, my client could have gone out and got a license. He could have incorporated, he could have expanded his own business. And just because he's a bad independent business person doesn't mean he's an employee. And again, the court really rejected that argument. That's not what the focus is on. And then just for this conversation, one of the pieces I really want to point out is that oftentimes courts focus on the flexibility that these workers have, meaning the flexibility to choose the hours that they work. And they say, well, that really can't be an employee. And the court, I think for the first time in any court across the country, really pointed out that just because they don't have regularly scheduled hours does not mean that they are automatically an independent contractor, and that flexibility itself does not control. And that is usually an argument that these companies like to make. The workers will often respond that yes, they have the flexibility to work 80 hours a week.
Julia, sorry to interrupt. I wanted to give you your 1 minute warning.
Yep, I am actually done. That was my last point. So we are good, and we're gonna move over to Omid.
All right, thank you everyone. Thank you, Julia and Nadia. Hope everyone can see my screen. So I'm going to talk about tax consequences of misclassification. And as was mentioned briefly before, so of course, when you are misclassified as an independent contractor, what ends up happening is you get paid on a 1099 or in cash instead of being paid as a W-2, even though you really are an employee. And one thing that Nadia said that I think is so important is that it is not what your employer calls you, because often we have clients who come in who have signed things that are called independent contractor agreements, and yet the facts show that really they had significant control over them in their jobs. They worked for a supervisor who controlled the methods and means by which they performed their work, so they really were an employee. And I should note that moving forward, the form that these workers, these misclassified workers would get if they were misclassified would be a 1099 NEC. That stands for non-employee compensation. But traditionally in the last several years, it's been a 1099 MISC, and you would see the income wrongly reported as non-employee compensation with no taxes being withheld. whereas of course they should have received a W-2 with withholding. And the effect of that is, of course, that then the worker is on the hook for both the employee and employer side of Social Security and Medicare taxes. Now, we've talked a lot about different definitions and standards that are used, and the IRS uses its own definitions and standards, and they more broadly focus on the common law definition, the common law standard of employment, focused on whether or not the employer has that right to control over the worker. There are some specific classes of employees that the Internal Revenue Code delineates, like salespersons and agent drivers, but they look at 20 factors that were established in Revenue Ruling 8741, and not any single factor is dispositive, but the basic question is, what was the degree of control over the worker? And those factors I should mention include things like whether the worker had a set schedule, whether they had a set rate of pay, if they were assigned certain tasks and had to comply with instructions about how and where to do their work. So when a practitioner sits down with a client to try and figure out if they were misclassified for tax purposes, I think it's important that they go through these 20 factors and make an evaluation based upon them as to whether or not the person was really misclassified, if they in fact were an employee. I'll touch just briefly on this issue, which is that, of course, employers are required to withhold Social Security and Medicare taxes and income taxes on their workers' pay. And in terms of the employee's share of taxes, if there is a finding that the employer has wrongfully, intentionally misclassified somebody and that they disregard their withholding obligations, it's possible that then the employer can even be on the hook for the employee's share of income tax and the employee's share of Social Security and Medicare taxes, including with penalties tacked onto that as well. But ultimately, employees are responsible for their own taxes and their own tax obligations, and that is something that still doesn't change. And that can be frustrating at times, because even if you were to successfully challenge your 1099 status and you still owe even just your employee's share of taxes, that can still be a lot, especially if you're paying it after the fact. Can you imagine if all of us on W-2s had to pay just our share of tax even after the fact? That's a significant amount of income, of course, and can be onerous, especially for our low-income clients. And in terms of the federal tax impact, principally of misclassification, misclassified workers end up being on the hook for the self-employment tax, 15.3% of your income, because it's the 7.65% employee share and 7.65% employer share of Social Security and Medicare taxes. Now, it's true that if you're 1099, you can claim expenses, which is no longer the case for employees after the Tax Cuts and Jobs Act. But the fact of the matter is that you're only going to get Social Security credit for your net income. So if you were to claim expenses, it's going to bring down your income for purposes of what's going to count towards your Social Security benefits. So it may not always be in your interest, in fact, to claim expenses. And so if you were misclassified, it is important to challenge it so that you can get on the books for Social Security fully, and so that you only pay your correct share of employees' taxes. And in terms of how you can make sure that you do that, you have to file what's called a Form SS-8 before the IRS. So the Form SS-8 is a 4-page packet that you file before the IRS SS-8 unit to challenge your misclassification as an independent contractor. And the questions relate to how much financial control there was over you in your job, how much behavioral control there was, what the relationship was between the parties. It basically boils down to those 20 factors that I referenced earlier. And so this is a way that you can attest before the IRS that you were in fact an employee and you were misclassified. And you would send this form to the SS-8 unit in Holtzville, New York, with any accompanying documentation. You got to make sure it's complete, even if there's situations where it's NA, you got to write NA in there, because otherwise the IRS might reject it. And what will happen is when you file this SS-8, this gives you the right to list your 1099 income as employee income, as wages, so that on your tax return, you only pay your employee's share of tax. What's really important to note is that this is not an anonymous form, so the employer will find out that you challenged your misclassification, and they'll actually be sent a blank SS-8 in which they will have to respond with their version of the facts. And then, pursuant to that investigation, the SS-8 unit will issue a determination as to whether the worker is an employee or independent contractor, a determination that they're going to share then with both sides. I should note that last year, the president signed into law the Taxpayer First Act, which provides a new whistleblower section that provides anti-retaliation protections actually for situations in which you file an administrative action and you allege that somebody didn't pay the share of tax that they should have paid. You can in fact protect yourself against retaliation from them should that come to be. So if somebody retaliates against you for filing an SS-8, you're potentially protected by this law. I don't know that we've seen many claims brought under it yet because it's only been in effect for a year, but it's something to look out for and something I think to advise clients if they're worried about that retaliation. And in terms of what filing the SS-8 actually means for your taxes, once you file the SS-8, that gives you the right to list this 1099 income as wages. And the way you do that is by attaching a Form 8919 to your tax return. The Form 8919 is really important because that's where you account for just your employee's share of tax. So let's say you're Dwight Schrute working for Michael Scott in Dunder Mifflin, and Michael Scott gave you a 1099, you misclassified you, even though you were assistant to the regional manager and you really were an employee, and he gave you a $10,000 1099, and then you realize that you were misclassified and you filed the SS-8. So on the 8919, you can make sure that on that $10,000 that you're only paying 7.65%, $765 that is, instead of $1,530, which would be the self-employment tax. So you save yourself a significant amount of money by challenging your misclassification as an independent contractor. Now, there are situations where we've seen people who get W-2 and 1099 in the same year for the same job with no real distinction in the kind of work that is being done. In those cases, you don't need to do an SS-8. You just do the 1040 tax return with an 8919, and you say, hey, I was really an employee for this 1099 income, and so that 1099 income, you account for just the employee share of tax on that on the 8919 and file it with your return. The good thing is, too, is that you can always seek refunds generally within 3 years of when a tax return should have been filed or 2 years from when a payment was made. But to make it really simple here, right now, the earliest year generally for which you can get a refund is 2017, because the 17 return, that would have been due in April of 18. So you have until April of 2021 to file an amended return for 2017 to get back refund of the employer's share of Social Security and Medicare tax that you shouldn't have paid because in fact you were misclassified. First you do the SS-8, then you do the amended return after that pursuant to filing the SS-8. You can also always go back and reduce balances for previous years as well, especially if you're paying them off through an installment agreement. We've seen that help a lot of our clients where they do SS-8 to challenge their misclassification for many years ago even. They're still paying off. And so then when they do the SS-8 and they file amended returns, they're paying less off ultimately and saving themselves money. You can find yourself in tax court challenging your misclassification if in fact you, as often happens, underreported or your preparer didn't report your 1099 income. You would get what's called a notice of deficiency that you have the right to respond to a petition in tax court. It may be that in these situations, by the way, you still will have to file an SS-8, but there are many tax court cases involving misclassification, and this is usually how they get there, which is that either someone didn't report the income or they owe taxes on the income and they weren't able to pay it off, so they get a bunch of notices for collection, and then they find themselves getting what's called a collection due process notice that they can challenge and say, actually, I should pay less in tax than this because I was misclassified. Employers also, by the way, can do SS-8s to figure out how they should classify their workers. And so workers are subject to those cases in the sense that they'll be affected by them, even though sometimes they're not actual parties to them. But those cases also can find themselves in tax court if the employer is being audited and the IRS has made a determination pursuant to that audit, and then the employer appeals that. So there's all kinds of ways in which misclassification plays itself out through the tax process and procedure. There's an interesting statute too, I should note here, this federal law 26 USC 7434, that says that you can get damages of up to $5,000 if your employer fraudulently filed an information return, like a 1099 or W-2. Now, this clearly applies to cases where, let's say your employer gives you a 1099 for $50,000, but you really made $20,000, and they did this with intentionality. Clearly, that is a violation of this law. It's not as clear whether or not it applies to just pure misclassification. Like if, let's say you're Dwight Schrute and you were misclassified, but there's no dispute that you actually made $10,000. The only dispute is you got the wrong form. No circuit court has ruled on this issue. The courts are generally split on this. The case law has unfortunately been mostly negative after the Eastern District of Virginia had this case called Liverett in 2016, where they dove into the legislative history and said, we don't think it applies to misclassification, but it's still something that's subject to a lot of debate. And I recommend checking out articles on it on Procedurally Taxing, a blog about taxes where they have a lot of good research on this. There are ways that you can also anonymously dispute your misclassification, like filing a whistleblower form, but neither of these methods here actually directly impacts your tax liability. The only way you can really do that is by filing the SSA. That gives you a direct means to challenge your misclassification. And if the SSA unit determines that you were misclassified, then the employer is on the hook, in fact, for their share of taxes, their employment taxes that they did not pay. They can still seek some kind of safe harbor relief and try and comply with the IRS through voluntary classification programs. But the SSA determination is a key thing to have, because that still will make sure that you only pay your share of tax as a worker. Now here in Pennsylvania specifically, there's no real difference, because on the PA tax return, everybody's taxed on 3.07% for their compensation. And one key thing is that, of course, unfortunately, if you were given a 1099, then you have to pay it all yourself, whereas when you get a W-2, it's withheld from your paycheck. But you can always challenge your misclassification through the Department of Labor and Industry. And you can, in fact, if you're a construction worker, challenge your misclassification pursuant to Act 72, the Construction Workplace Misclassification Act that was referenced earlier. You can even do that online. But if you're not a construction worker and you're misclassified, you can always report your misclassification through the Office of Unemployment Compensation Tax Services. And I've spoken with folks who work there, and they have compiled great reports every year on the misclassification investigations that they do and the fines that they've been able to collect throughout the state from employers who unfortunately intentionally, wrongfully misclassified their workers. But we're always here in our low-income taxpayer clinic as a resource for low-income Philadelphians who were misclassified by their employers, and we want to make sure that we protect a key pillar of the Taxpayer Bill of Rights, that you only should have to pay the correct share of tax. So now I think we have a few minutes for questions. I'll stop sharing.
Sorry, this is Kelly. I'm launching the second of the CLE poll boxes. Please respond. You'll have a minute and a half to do so. And please feel free to continue.
All right, so I guess we will take questions now in the chat. If anybody has them, please make sure to post in there. Thank you everyone for joining us today as well. It seems like we have a pretty significant audience, so we're happy about that.
So if you have any questions or comments for our presenters, please put them in the chat box now. And I think there's something.
Becky Stavish, my colleague at Mid-Penn Legal Services in York, makes a great point that if you have a client who's not in Philadelphia, then of course they can go to another low-income taxpayer clinic like hers If you're in the York, Lancaster area, there's Villanova Federal Tax Clinic run by the wonderful Christine Spidell, who is an expert, and they can help people in the Collier counties. Looks like we have another question.
I think that's an unemployment question for Julia. When the employer has the burden of establishing wages on appeal, is there a benefit to not bringing claimant into hearing if employer fails to show?
I don't think so. Even though technically the employer has the burden, if there is evidence in the case by the department from a wage investigation or anything else, especially anything between employer and claimant that corroborates each other, that could be used as evidence. And generally speaking, if you are contesting this, your client's testimony is going to be pretty good, right? Like if you believe that they were misclassified, especially if there's not an employer there to contradict them. So I've always brought the claimant into those hearings.
Any other questions? I believe I hit a button to allow folks to unmute themselves in case you want to ask a question orally.
Actually, I had to do it, and I just did.
Oh, thank you, Kelly.
Sure.
We're all friends here.
I think Nadia made a great point that this is such a timely, salient issue because you've got Prop 22 in California up on election day that would potentially repeal California's new protections for workers, and you've got the DOL's pending regs. So this is definitely something to expect to see in the news continuously a lot over the next several weeks, months, years, really, especially with the gig economy on the rise.
And
I also wanted to say,
go ahead, Nadia.
Oh, I was going to say that if you're doing wage and hour law, there's overlap between this misclassification issue as well as joint employment. So they're related but not exactly the same in terms of how you can make multiple employers liable for non-payment of wages. And the laws are pretty flexible on that. So just I would recommend that you look into that if you have a situation where someone's subcontracted in order to avoid payment and avoid other liability. Go ahead, Julia.
Yeah, so for those of you who are representing gig workers right now who are currently covered by the extension of unemployment benefits to the pandemic unemployment assistance system, that ends at the end of December, and right now it's not looking good for any extensions of that program. I will be reporting back and sending out information later in the year as we try to work with the department on leveraging Lohman to change the initial evaluation of worker status for gig workers, primarily drivers, prior to the end of the year in the hope that we might be able to move those gig workers, again, primarily drivers, since that's where the strongest law is right now, over to the unemployment system come January.
Okay, if nothing else and no other questions, I would like to thank our presenters for today, for giving of your time and all the wonderful information. Thank you to attendees for being here, and we hope to see you for another session again soon. Everybody take care. Have a good rest of the day.
Bye.
You too. Thanks, Kelly.
Thanks.